NBC's journey began in the early 1980s under the Alexander Forbes banner, under the inspirational guidance and vision of our founder, Max Maisela, who dared to ask a simple question no one ever thought to ask. Why employees should not have a say in the design and management of their retirement funds. The right way, the fair way, the negotiated way, to ensure that all employees get the benefits to safeguard their dependents' financial well-being and to provide financial security for their own retirement. The concept of negotiated retirement funds with member representation on the Board of Trustees became the industry norm, and today it is law. In 1998, Max Maisela's dream became a reality, and after a management buyout, NBC Holdings Proprietary Limited was established, the first completely independent, black-owned and managed financial service company in South Africa. NBC has during the past 2 decades been part of an illustrious list of top-performing companies and received over 50 unsolicited local and international awards and accolades for innovative products and outstanding service delivery. NBC has an impressive list of clients from government institutions within the SADC region, parastatals to blue-chip companies. NBC is committed to transparency and regularly facilitates educational workshops and communication sessions to keep our clients and the members of funds informed about benefits, investments, and all legal amendments pertaining to retirement funds. In the past decade, NBC has expanded into other African countries such as Namibia, Lesotho, Swaziland, Mozambique, and Ghana, where NBC works together with locally based partners to provide innovative financial products and solutions designed to meet the distinctive needs of people within that country. NBC has evolved and organically grown through self-funding into a multi-dimensional, highly successful and innovative company built on solid foundations and geared for healthy growth within South Africa and beyond.
Good morning and welcome to the NBC Legal Webinar. This will be our final session for the year, so we are happy for everyone who could join us. And we hope that today will be another informative session and that everyone who attends really gets something that will ensure that they have growth out of it. So just before we begin, please remember that this session is CPD accredited. You will need to download your certificate right after the streaming session is complete. So please ensure that you download it immediately after the streaming session is complete. When you watch the recording at a later date, if you're watching a recording, there will be no ability to download a CPD certificate. So just to get that out the way. So our first speaker is Esther. So I'm going to pass it over to Esther.
Thank you so much, Nicole. Today I'll be talking to you guys about the phase fit and proper requirements. And I'd like to thank all of you who've managed to join as I take you through this presentation. If you could share my screen, it's still on. All right. So I just wanted to start by saying that the phase fit and proper requirements emanate from the FASE Act, which is the Financial Advisory, Intermediary and Services Act. And this act specifically aims at ensuring that consumer protection is guarded and that financial advice and intermediary services are rendered in a professional manner. And this is because we're dealing with people's monies. And when we're dealing with people's monies, we have to be in a position of trust and are able to be accountable to the individuals that we're dealing with, or our clients, so to speak. And Board Notice 194 of 2017 was introduced recently, and it came up with a few more fit and proper requirements that were previously not in place. And these fit and proper requirements aim at guarding TCF principles And we will see as we're going through the TCF or the fit and proper requirements themselves that TCF has become a big component, and TCF stands for treating customers fairly or treating clients fairly. It's become a big component of the financial services industry at large. The fit and proper requirements that are now in play are operational ability, continuous professional development, financial soundness, honesty, integrity, and good standing, and competence. And the people that are required to be fit and proper are key individuals, key persons within an organization or a financial services industry, and the representatives, and the financial service provider itself, which means the company itself. The company should be fit and proper, specifically when we're dealing with their operational abilities and financial soundness requirements. So a key individual is in charge of ensuring the operational ability of a business and is also in charge of ensuring that the competency register is maintained by its key individuals and representatives, because there are some timeframes by which a person must maintain their fit and proper requirements. And I'm going to take you through these timeframes as we go on. So as I mentioned in the beginning, when we're dealing with financial services, we're dealing with financial services in the sense that you either give advice or intermediary services within the financial services space, or there's an aspect that we don't really touch on as it doesn't really apply in our industry, and that is the discretionary services, where a client gives you discretion to deal with their financial products, and you don't have to keep going back and forth with them to sign on each product that you sign for the client. So advice is any recommendation, guidance, or proposal that is given to a person which relates to purchasing, investing, or changing a financial product on behalf of a client. And then intermediary services would relate to the activity that other than advice, where you're not actually giving them advice, but you are exercising judgment on behalf of the client to administer or keep in custody or collect premiums on behalf of a client. So when you're doing all of these things, then you would be deemed to be within the financial services space, and hence you would have to meet the fit and proper requirements. So I'd just like to take you through the fit and proper requirements that apply to key individuals, financial service providers, and representatives. The first being operational ability, the second being continuous professional development, competence, and we're going to deal with the competence requirement quite heavily because that applies to representatives. And in our space, that would be the consultants, financial planners, or any investment advisors that deal with financial products and give advice to clients or funds, so to speak, with regard to their financial products. And then the other component is honesty, integrity, and good standing. And then there's the financial soundness. So let's start with the honesty, integrity, and good standing and what it means. So when we talk about honesty, integrity, and good standing, we're talking about how upstanding you are as an individual. Are you honest in the sense that have you gone through any fraudulent claims laid against you? Have you had an adverse judgment that relates to fraud that was laid against you in a court of law? Or perhaps you've been denied some sort of license for some reasons that relate to fraud or dishonesty, so to speak. And a person who is not a natural person must show that it complies with the requirement of honesty in the manner that they deal with their corporate behavior. And that can be done through a governance structure. So now the fit and proper requirements require a business to have a governance structure that they put in place to ensure that you show your fit and proper requirements. Also, your key persons are now required to show that they are also people that are honest, of integrity, and good standing. Key persons would be your directors or any persons within the management and who are of influence in relation to how the business is run. They are also now required to be of good standing. So as I mentioned, the authority will look at things such as whether the person has been found guilty in a court of law of a crime or even a civil court of law, and also has been denied membership, has been found guilty by a regulatory body, have you been debarred before, and if you are to come back onto the register, if you've been found previously to be dishonest, you would find that you would need at least 5 years rehabilitation before you are added onto the register again. And even then, it's not guaranteed. The FSCA would have to look at each case on its own merits to understand the reasons why you had been debarred in the first place for dishonesty. So honesty and integrity is an ongoing process. And what I mean by that is that you do not just declare in the beginning. Previously, you noticed that we used to do a declaration form, and you would complete the form to say, yeah, I haven't been found guilty of a crime, etc. But now we need to make it should be embedded in our governance processes. Or if you're a financial service provider, this should be embedded in your governance processes, in the sense that you regularly check whether your representatives, your key persons, and your key individuals are still fit and proper when it comes to honesty and integrity. And these representatives and key individuals or key persons are required to inform the financial service provider through their compliance officer or manager if there's been any change to the declaration that had previously been signed. This is an obligation that they're supposed to understand. I'll just give an example of dishonesty where it comes to a woman who applied for a license using a false matric certificate, and she was found guilty in a court of law. And after she'd been found guilty, she had to wait for a period of 5 years to apply for a license again. And even then, if she applied, there was no guarantee that she would get the license. She would have to show that there's been a genuine and complete or permanent reform, and that the defect or character that led to being convicted no longer exists. And if authorized, she would need to conduct herself honorably, and she should show that she is someone who can be trusted. And the authority would need to consider all of this before they can provide her with the financial service provider license. The second requirement that I spoke of is the operational ability, and this heavily falls on a company or the financial service provider itself to have proper operational ability. And this relates to key individuals ensuring that a financial service provider meets its requirements. And for instance, if there are more than 2 individuals within a financial service provider, what I mean by that is there's maybe a key individual and 2 representatives, they should appoint a compliance officer. Where a person has a financial service provider license and they are both the key individual and representative, and there's no one else on that license, then they themselves can be compliance officer for their own business, and only in that instance. If there's more than 2 individuals providing advice, that is key individuals and representatives, you would need to appoint a compliance officer. So in the 2017 Fit and Proper Determination, we find that there was an introduction of a governance requirements. It requires that a governance framework is introduced by a financial service provider where they can show the nature, scale, risks, and complexities of the business. And in this, they need to include a business plan, an accounting policy to enable the FSP to record, report, and deliver financial products, or reports, and also a business continuity policy that guards against interruption of business. This relates to where, for instance, one of the key individual, or if there's one key individual, he passes away, then there's an obligation to show that you have a business continuity or succession plan in those instances. And all of this should be covered within the governance framework, amongst other things. The other requirement is the financial soundness component. The financial soundness component requires that a financial service provider, its representatives, key individuals, or jurisdiction representatives must not be unrehabilitated insolvents or under liquidation or provisional liquidation. The most important, and this was present even before the 2017 Fit and Proper requirements, is that your assets must always exceed your liabilities. And the second is that you must at all times maintain financial resources that can adequately carry out your expenses if that need arises. And you must also meet the capital adequacy requirements depending on the license you hold. So say, for instance, when looking at NBC Holdings, NBC Holdings would be required to maintain an 8/52 weeks annual expenditure in liquid assets. And this is because not only is it a category 1 financial service provider, but we also collect premiums on behalf of insurers, which is why we would be required to have that obligation. So being a Category 1 financial service provider that collects premiums, we need to implement a financial strategy to assess and maintain on an ongoing basis adequate financial resources. And these must include that we comply with the asset requirements, and then we must submit an Annexure 6 Form A form, and we need to show that our assets are never less than 10%. Our assets or current liabilities are never way more than the 10% threshold as well. And that if any of the financial soundness requirements are not met, we make the FSCA aware of this with immediate effects. Now, we're going to look at the continuous professional development. These can fall under the competence requirements, but I decided to look at them separately because continuous professional development is dealt with differently because every year this is a requirement. It's not a once-off requirement. And key individuals and representatives that are no longer under supervision have a duty to maintain continuous professional development. And you might say, perhaps, I've been in the industry for a very long time. I have the experience. I've been doing this for 20 years. Why am I required to do continuous professional development? The reason is because when we're dealing with continuous professional development, we are looking at the fact that you need to develop yourself as the industry evolves. Especially of late, we see that there's been a lot of regulatory changes within the industry, both within the pension fund space, the financial services industry as a whole. There's been a lot of legislation that has been introduced. And the only way to stay relevant and up to date is to conduct these continuous professional development exercises. And the requirement is that you not only do specific continuous professional development exercises that relate perhaps to just ethics, but you should also look at technical CPD requirements, generic CPD requirements relating to your specific company. You need to meet those. And when I say this to mean that even though it's not a requirement for CPD for those that are still under supervision or have not met their other competence requirements, the requirement is that within your company itself, some of the CPD accredited trainings that are provided require you to stay up to date for the purposes of rendering your services or duties appropriately. An example is FICA, for instance. Even though you're not required as a representative that's under supervision to maintain CPD points, if those CPD points relate to FICA would then be an obligation because in terms of the Financial Intelligence Center Act, which is FICA, you need to have annual training or refresher training of FICA for the entire company, whether or not that person is a representative, whether they are under supervision or not. So some of the CPD activities or programs that are offered within the company may become compulsory for you to embark on because of the services that you provide within your company or entity. So that is quite important to note. The minimum CPD hours that are required at any given time is between 6 to 18 hours. These would be determined by the type of products or subclasses that you are registered for as a representative. So the more subclasses you have would determine the CPD hours that you need to serve. And the CPD cycle would start from the 1st of June up until the 31st of June every year. And then within 45 days of completion of your CPD hours, you would need to submit to your FSP or compliance officer evidence that you have obtained the CPD points that are required. And these CPD points have to be acquired through an accredited body. So previously, you could just show that you went to a presentation and not necessarily have those CPD hours accredited. But the new requirements are that the CPD hours that you obtain have to be through an accredited body, and usually you would then be issued with a certificate after obtaining those CPD hours, such as these legal webinars that we're having right now. These are also CPD accredited, and you would get the certificate to show for it. Okay, now I want to get into the competence requirements. And the competence requirements are very important because these apply specifically to key individuals in their individual capacity and representatives, and there are time frames by which they should have obtained the fit and proper requirements that relate to competence. And the competence requirements are experience, qualifications, regulatory exams, class of business training, and product-specific training. So before the 2017 board notice, we noted that there were only 3 of these requirements under the competence, and that is experience, qualification, and regulatory exams. They have now added the class of business requirement and product-specific training requirement, which by now everyone should be familiar with, and any representative or key individual should have obtained the required competence requirements, so to speak. So the first one we're going to look at is the experience component. And when we're looking at experience, the experience that you are required to obtain depends on the license or subcategories that you are registered for. So if you're a category 1 to 4, a category 1 and 4 financial service provider, it usually ranges between 6 to 2 years. But if you're a category 2, 2A, or category 3, and those are service providers that offer discretionary services, that would have to be between 2 to 3 years of experience that you need to show before you can be removed under supervision. And the experience needs to be practical, hands-on experience, and your supervisor needs to then decide, looking at your development, how long you need to be under supervision for. And they need to document, well, the representative is responsible for documenting their own supervision experience, and the supervisor or key individual would have to sign off on this experience to show that you have the required experience for the subcategories that are required. For key individual, this experience could have been gained outside of South Africa, or it could have been gained within a specific period. But if your experience has now exceeded 5 years, both for key individuals and representatives. And what I mean by that is, say, for instance, you are in the industry and you leave the industry for whatever reason for a period more than 5 years, or say you're working for a short-term insurance company and you join a pension fund space or administrator, and now you're not doing short-term, and then you go back to a short-term insurance environment after more than 5 years, you would need to start your supervision period again. So what I'm trying to say is, if you no longer serve within the financial services space or the categories that you would have obtained experience for a period over 5 years, when you go back to that environment, you can't say, oh, I was in this space in 2014, because it's been more than 5 years and the industry would have evolved significantly. The requirement is that you would need to serve under supervision for the specified period in terms of the fit and proper requirements again. All right, now we want to look at the qualification component of the competency requirements. With the qualification component, it's become quite tricky in our industry or in the financial services industry as a whole, because you find that historically it was sufficient for you to have obtained a skills program. And if you've been in the industry for a very long time, you would know what I'm talking about. Say, for instance, you did a short-term skills program in long-term insurance, and that was 30 credits. That would only be sufficient to serve as a qualification if that component is being serviced for you serving the same exact position. In other words, you haven't added any new products to your categories, and you're still doing the exact same thing under the same exact product, then you can say you have sufficient qualification. The minute that your position changes or you start adding new products to your categories, then you would be required to have a full qualification. So in essence, what I'm saying is you're required to have a full qualification under the new, not so new fit and proper requirements. And a full qualification would be 120 credits or upwards. So if you have 120 credits for a short-term insurance qualification, for instance, and then you join an industry where they do life, you would be required to do a new qualification that relates to that specific industry. And when it comes to qualifications, on the FSCA website, they have a list of recognized qualifications. And this list is not static. In other words, the list is updated quarterly. And if you have a qualification that you do not find on this list of registered or recognized qualifications, you can actually submit to the FSCA to have your qualification recognized. And what that means is that because your qualification is not on the list, it doesn't necessarily mean that it is not recognized. What you need to do is to have a transcript that shows the subject matters that were covered within your qualification, so that they can use the qualifying criteria that they have to assess your qualification and see whether it's relevant for your specific industry or your specific role, and then they can recognize it. And qualifications are not recognized for specific individuals. So say you submit your qualification, they're not recognizing it just for you. What they do is they add it to the list of recognized qualifications, so that whoever comes and has a similar qualification, they can see that that qualification would have been added, and hence that qualification would be recognized for everyone else. Also, you find that sometimes you have a BCom, for instance, and your BCom is with a university that is not on the list. If that's the case, you are also required to submit your specific BCom to the FSCA for recognition, because what they do is they recognize per university or college based on the criteria that they would have received for that specific university. So maybe if yours is not in there, they would need to assess your specific qualification or BCom to see whether it meets the relevant qualifying criteria. And you need to have obtained a qualification within 6 years of your date of first appointment. What that means is you can not be under supervision for a period of more than 6 years. So if you have not obtained your qualification for a period that's longer than 6 years, you would need to be debarred or removed from the register up until that time that you obtain that specific qualification. With regulatory exams, the most important regulatory exams that we deal with are the RE5, which are for representatives, and the RE1, which is for key individuals. But there are other regulatory exams that relate to products. So if you're now dealing with category 2 financial service providers or 2A, you would then have RE3, for instance, RE4 that you would need to also add to that list. And you need to have obtained your regulatory exams or have written your regulatory exams within 2 years of your date of first appointment. And when I say date of first appointment, I mean the date on which you were first added to the representative register, regardless of which company it was. So even if you move from one entity to another, say for instance, you leave an Old Mutual and you go to Alexander Forbes, the clock does not start ticking when you move to Alexander Forbes. It started ticking when you first were registered with Old Mutual, and you need to have obtained your regulatory exams within that 2-year period. And then the RE1 for key individuals, you would only need to write if you want to be added as a key individual, or your entity now requires you to be added as a key individual. Now, the class of business training is one of the new requirements that was added on the competence requirements. And this you need to have obtained within the first year of you being registered as a representative or key individual. And they've added a few classes of business, and I'm just going to go through the list quickly, which are short-term insurance within personal lines, short-term within commercial lines, long-term insurance, pension fund benefits, short-term and long-term deposits, structured deposits, investments, forex investments, and health services. So, and class of business training can only be provided by an accredited education institution. and you need to have completed it within the first year, as I've already mentioned. So you need to identify, or your entity will identify the classes of business that relate to that specific entity, and then you would be required to then get the classes of business that are relevant to you. If you're a key individual and you would like to be added for instance, as a key individual for other products that were previously not on your DOFA, then you would need to obtain the relevant class of business as well. When it comes to product-specific training is only a requirement for representatives. And representatives are required to obtain this product-specific training prior to them actually being registered as representatives, or prior to them offering financial advice or intermediary services. And key individuals do not have to complete this product-specific training. And you need to look at specific components when you're dealing with product-specific training, things like the target market of the product, the expected outcome, the potential impacts on the economy, and the investment strategies of the actual product, and the costs involved with that specific product. As I mentioned, the consequences of not meeting the fit and proper requirements would mean that you would need to be debarred. And as I mentioned, specifically when we're dealing with the competence requirements, regulatory exams need to be obtained within 2 years of you being registered as a representative. Qualifications need to be obtained within 6 years of you being registered. Class of business would need to be obtained within the year, and product-specific training would need to be obtained prior to you rendering your services as a representative, so to speak. And if you are unable to meet the fit and proper requirements, you need to then explore being moved into another department, because then you can't serve as a representative if you are not meeting the fit and proper requirements. So you might need to be transferred into another department, or the business might need to assess whether they still need your services, or then they would be at risk of having to answer a lot of questions. That was it on the fit and proper requirements. I tried to make it as short and sweet as possible, although there's a lot of components that we didn't really deal with, but we will send the presentation together with a link to the actual board notice, so that you look at aspects that relate to your financial service provider, if you are in that space, or to you as a representative or key individual, so that you understand better what is required of you. Thank you so much. I look forward to answering all your questions. Back to you, Nicole.
NBC Legal Services. The NBC Legal Department consists of qualified lawyers who handle generic and complex legal issues applicable to the retirement fund industry. In addition to our legal services, we offer free legal seminars as a tool to equip our trustees and employers with the appropriate technical knowledge through frequent seminars hosted across the country. For more information, please see our website www.nbc.co.za or contact us on info@nbc.co.za.
Thank you so much, Esther. That was a very informative session, and I'm sure we'll get quite a few questions on that. Just a reminder, should you have any questions, please put them in the chat, and if we have enough time, we'll definitely address them. If we don't have enough time, you will be able to email or contact each presenter regarding their topic. So up next, we have our Senior Legal Advisor at NBC Legal, Carla.
Thank you so much, Nicole. Welcome, everybody, and thanks for joining us this morning. I will be dealing with Sections 37D deductions, more specifically the withholding and the fair treatment for employers and members when it comes to this issue. All right. So an employer can claim from a member's retirement savings for losses suffered as a direct result of damages caused by that member. Many employers struggle to follow the legal process required to recover these losses. So I thought it would be a great platform to explain to board members as well as employers, what specific requirements they need to tick off to make sure that the request to withhold or the deduction is in fact enforceable against the fund. So the background for this is Section 37A prohibits a member's benefit from being reduced, ceded, transferred, or attached by creditors. Now, like I explained, Section 37D of the Act does permit certain deductions. So specifically in regards to this session, it is where a member caused damages to his employer by means of his dishonest behavior, fraud, theft, and then misconduct. Misconduct in this sense should be interpreted to include an element of intent. Mere negligence does not suffice. So what we see a lot is IOD submitted by employers. For example, the member was a driver and he was involved in an accident due to his negligent driving, and now the employer made him sign an AOD for the excess payment on the insurance claim. So mere negligence in that sense, it does not fall within the ambit of this specific section. Let's just go back one. Okay, Section 37(1)(b). Let me just explain the requirements to be met. There must be a pension benefit payable to the member. There must be an amount due by the member to his employer. And like I said, damage caused to the employer must be by reason of theft, dishonesty, fraud, or misconduct. And like I also mentioned, misconduct in this sense should be interpreted to mean conduct which contains an element of dishonesty and thus excludes negligent conduct. The members must admit liability in writing to the employer, or a judgment must be obtained in a court of law. Also important to note, the written admission must be made voluntarily, and the specific amount of compensation for damages must be outlined. And also to add on to this, there must be a description in the acknowledgement of debt surrounding, explaining what behavior gave rise to this damages. So Section 37D makes a provision for the deduction, but the employer can also ask the fund to withhold the payment of pension benefit pending the outcome of court proceedings. So a member often leaves employment before the employer could manage to get a valid signed AOD, or the employer instituted civil proceedings, and we all know the court process does take some time. So, giving the employer a reasonable period to finalize the proceedings, the section can then be interpreted to also include withholding. So in such circumstances, the fund is invariably requested to withhold the member's retirement savings. So what gave rise to this interpretation comes from, I think, the well-known Highveld Steel case. So in this case, like I mentioned, it must be interpreted to include the power of a fund to withhold a member's benefit, to afford the employer an opportunity to get the written admission or the relevant court order. Further from this case, it can be noted that the discretion must be exercised with due care by the fund. So the fund must scrutinize the claims made by the employer. The fund must balance the competing interest of the member and the employer. Very, very important point. The fund must have due regard to the strength of the employer's claim. So the second case law I would like to refer to is the Jeffda matter, which came after the Highveld Steel matter. In this case, the court determined that before a fund exercises its discretion whether to withhold savings or not, the employer's case must be put to the member to afford him an opportunity to respond. If the fund does not do so, it cannot be said that it has applied its mind properly, impartially, and in a balanced manner. If the member is not heard, the board has failed to comply with the Hartfeld Steel case, and the withholding is wrongful and will be set aside if challenged. So this is very, very important to remember when you get a request from an employer to withhold. Should the member in question then approach the adjudicator's office? And from the fact she could see that the fund never approached the member and gave him a chance to answer to the allegations made against him by the employer, the adjudicator might, with all probability, will put the decision aside and order payment of the member's benefit. So the third case, and the most recent one, is the tape aids for the blind. This is a PFA matter that went on to the Financial Services Tribunal. The tribunal determined that Section 37C(1)(b)(2) of the Pension Fund Act requires the fund to have regard to the competing interest of both employer and employee when exercising this discretion. The PFA considered the fiduciary duties of the fund, and reference was made to the more recent JEFTA matter that I referred to just earlier. Of importance was that the fund failed to weigh the competing interests of the parties, and in particular that it was remiss in not requesting the employee to make representations. The fund further failed to conduct an inquiry as to the financial prejudice that the member may suffer and weigh that against the employer's case. And I also would like to refer to Section 7, more specifically 7C2, that deals with the fiduciary duties of board members. This section places an obligation on the board of the fund to take all reasonable steps to ensure that the interests of members in terms of the rules of the fund and the provisions of the Act are protected at all times. It is not expected of the employer to prove fraud, dishonesty, theft to the fund. That is for the court to prove. Neither is it for the fund to make judgment about whether the case of fraud, etc., has been proved against the employee by the employer. The fund must merely be satisfied that the employer made out a prima facie case against the member and that there is reasonable chances of success in the civil litigation that has been instituted against the member. So the question now is, how does an employer claim for damages? Like I mentioned, it should be in the claim in respect of damages, and to lay a claim, the employer must obtain, like I said, an admission of liability. And just to reiterate, when the employer gets the member to or negotiates the AOD with the member, it must state the specific amount of the alleged damages that was caused by the member, as well as the circumstances surrounding. If that is not stipulated in the AOD would not be enforceable against the fund, and the fund will not be in a position to withhold. But like I indicated, the employer is not without recourse. They can always request the fund to withhold. All right. So like I said, it's important to understand the distinction specifically between a deduction from a benefit and a withholding of a benefit and the requirements that apply to each. I will now go in a little more depth in terms when it comes to the request for withholding of the benefit. It is not an automatic right that is always and is always in the discretion of the trustees. So when an employer submits a request to the fund to withhold, it's not a given that the fund will grant the employer its request. Factors that the trustees should consider include the following. Has the employer instituted legal proceedings against this member in an attempt to recover the damages? Is this employer actively pursuing and not just filing civil litigation and sitting on its laurels, or lodging a claim with the SAPS and not following up with the investigating officer, etc.? Is there a reasonable chance of success? And the employer is not responsible for any delays in the legal proceedings. For the trustees to determine whether the withholding is reasonable, the following documents must accompany the request to withhold a benefit. So this is important for funds as well as employers. Whenever such a request is submitted, it always has to be accompanied by the following. The SAPS case number, in an instance of civil litigation, a copy of the summons, return of service, etc. Like I've mentioned, the estimated loss suffered. The employer, in terms of the Act, is also able to include reasonable legal fees. So that can also be included in your estimated losses suffered. Any disciplinary hearings, internal inquiries, notices of dismissal, or any other such supporting evidence that will enable the trustees to understand the conduct that caused the loss to the employer. Obviously, the completed withdrawal claim form, and then the employer should continuously update the fund on or where they are in the recovery process. And then also important to note, just a criminal judgment or conviction is insufficient for the employer to be compensated. So together with the criminal judgment, the employer also has to bring an application in terms of Section 300 of the Criminal Procedure Act. So whereby the employer also requests for a compensation order for damages to be recovered from the member's benefit. All right. Next question is, what portion can be withheld from the member's benefit? So in instances where the member has a benefit, say for example, 100,000 Rand, and only damages in the amount of 60,000 Rand was caused by this member, the fund will not be in a position to withhold the member's entire benefit. So they might withhold the portion of the damages that's claimed by the employer, and they should release the balance of the payment to the member. The Act allows for like I mentioned, the Act allows for an employer to include legal costs in its claim, which were or will be included. The employer should therefore provide the trustees with a reasonable estimate of legal costs as well. So in closing, I'm almost drawing to the end. Important points to note or to reiterate is the employer should notify, the employer and the fund should notify the administrator as soon as possible about any claim that the employer may have against a member's benefit. Any request for a deduction from a member's benefit must be accompanied by the signed and completed AOL, and I did touch on the specific requirements that that has to be met in order for the AOL to be enforceable and for the immediate deduction to take place. Civil or criminal judgment with the compensation order, like I explained in terms of Section 300 of the Criminal Procedure Act, a completed withdrawal claim form. If a judgment has not been obtained, all supporting document, including case number and any other document submitted to SAPS. The Board of Trustees must receive constant updates for the withholding. So the board is also not permitted to withhold indefinitely. So the board has a discretion for a reasonable period. And I'll get to that later, but it's difficult, specifically in instances when it comes to criminal investigations or criminal procedures that has been instituted, because we don't know, once the claim has been lodged or the docket has been opened, how the SAPS will be driving the investigations and so on. So it might take very long for the criminal procedure to get to a closure. So it's important for the employer to continuously update the fund in terms of the recovery. Like I said, an employer it's not an automatic right to withhold and prevent the member from accessing their benefit. But this might count against their claim. Only a request made to the fund, together with a claim form and necessary motivation for withholding, will enable trustees to decide whether to withhold the benefit. We do see in a lot of these instances where we receive a request to withhold that the employer refuses to submit the claim form or stamp the claim form. So the fund needs to be in position of a fully stamped and completed claim form together with the motivation for the withholding. The fund must weigh the competing interests. So this is the fair treatment for member and employer, or employer and employee. And it must request the employee to make representations regarding the employer's request to withhold. So, interestingly to note, at the recent IRFA conference, the Adjudicator's Office also presented at the conference. And they also referred to the most recent tape-outs for the blind case, and stated that the Financial Services Tribunal has continuously held that where there are no civil proceedings pending, a fund does not have the discretion to withhold a benefit. Criminal proceedings are insufficient. So I'm going to run through the extracts of the tape aids for the blind case on which they relied on to come to this statement. There is no basis on which the fund or the PFA could have been satisfied that tape aids for the blind has instituted or will institute civil legal proceedings against the complainant within a reasonable period. Section 300 of the Criminal Procedure Act provides that where a person is convicted of an offence which has caused damage to loss of property, including money, belonging to some other person, the court in question may, upon the application of the injured person or of the prosecutor, acting on instructions of the injured person, forthwith award the injured person a compensation for such damage as or loss. Such an award has the effect of a civil judgment. The next question is whether fraud, as alleged by Tape H for the Blind, is covered by Section 300 of the Criminal Procedure Act. It goes on to say, assuming that it is covered by Section 300, the final issue is whether laying a criminal complaint amounts to the institution of legal proceedings. Instituted or will institute legal proceedings. Criminal proceedings are instituted by the state through the prosecuting authorities. Laying a charge has no legal consequence. It does not begin a legal proceeding. Legal proceedings may or may not follow depending on the decision of the prosecutor. So it would be advisable for the employer not just to request the withholding and to open an SAPS matter, but also to actively drive the recovery of the money by also instituting legal proceedings through the civil procedure. And that's it for me. Thank you for joining my session, and I look forward to answer any of your questions that you might have. Back to you, Nicole.
Thank you for that, Carla. That was a lovely session. Up next, we have Dabe.
Good morning, everyone, and thank you for attending this webinar, which I hope will be beneficial to yourselves and you leave here better informed. To get started with my presentation, just to look at the overview, and I'll start off by highlighting the legislature that actually speaks to risk management being one of the duties, fiduciary duties of the board of fund. The Pension Fund Act in Section 7D B states that one of the duties of the board is to ensure that proper control systems are employed by or on behalf of the board, ensuring that a pension fund has proper control systems as part of the risk management process in a fund. Principle 7 in Circular PF number 130 refers to risk management, and it states that the management of risk in a fund is a vital component of the governance of a fund. It further states that every fund should have a risk management policy in place. The board is ultimately responsible for ensuring that any risks faced by the fund are effectively and adequately managed. So the next question to ask is, what is risk management in the context of a pension fund? By definition, this is a 4-step process, which entails identifying the risks faced by the fund, assessing those risks once we've identified them, controlling those risks to ensure that they don't obviously affect the fund, and then monitoring those risks that have been identified, assessed, and controlled. So just to go into further detail on each of those processes, starting off with the identification of risks. This process is conducted to answer the question, what could go wrong? So as the board of fund, that's a question you'd ask yourselves at the identification stage of the risk management process. So what could go wrong in the fund that could impact on its operations or in a significant way, as well as impact, have an adverse impact on the going concern status of the fund? The board must identify any unwanted events, undesirable outcomes, and emerging threats that are relevant to its fund, as well as those that are generic within the industry as well. So we've got to look at those that are specific to the fund, as well as those that might be generic within the industry. And this process should be ongoing. Then in terms of assessment of risks, once the board has identified the key risks faced by the fund, it must assess the likelihood of these risks occurring, as well as the potential impact on the fund of each of the risks identified. Thereafter, each of the potential impacts of these risks must be rated in the following categories: low, moderate, medium, and high. Risk assessment should be done at least annually, and where it is feasible, should be done biannually. And then the controlling of risks. This process must be conducted by the board to identify the most effective mitigating actions that must be put in place to reduce the likelihood of the occurrence of the risks identified in the risk identification process. The board must also ensure that these mitigating actions are actually implemented. And then the monitoring of risk. This process is an ongoing process, and it entails monitoring the effectiveness of the mitigating actions that have been implemented to reduce the likelihood of these risks occurring. So that's a very critical step, because if there's a failure in terms of the monitoring, then there's a likelihood that some of the mitigating actions might cease to be effective in terms of warding off the risks. And then going into the risk management policy. As I stated earlier, Principle 7 of the Circular PF number 130 states that every fund should have a risk management policy, which should be reviewed annually by the board. And this policy should include details of the following: the identification of the key risks facing the fund, assessment of the impact of the key risks identified, the processes or controls that need to be put in place to mitigate the impact of the key risks, the monitoring of the processes or controls to ensure that they're effective and appropriate, communication to the members and stakeholders of the fund's risk management policy, including the identification of key risks and processes or controls in place to manage them. The fund may also include what is called a risk appetite statement. So in that risk appetite statement, the fund would clearly define the amount of risk that it's willing to accept to achieve its objectives. This would be most appropriate when it comes to investments. In my external auditing part of my career, I would note that the investment policy statements, there would be a point in there that would state that the fund is not going to invest in derivatives. So that's would be an example of a risk appetite statement, wherein the trustees are saying, in as far as investments, we will invest in every class except for derivatives. Then we move on to the risk register. To assist the board in executing its risk management responsibilities, there is a document known as the risk register, which is used as a risk management tool. The risk register serves as a record of information about the risks that have been identified, and it also contains a matrix, and it's a living document that contains additional information such as the following: the nature of the risk identified, the risk category, because we categorize the risk. Is it a compliance risk or is it an operational risk? We could also include strategic risks, the detail of the impact to the fund should the risk occur, the likelihood or probability of the risk occurring, as well as the rating of that, which we disclose as low, moderate, medium, or high. Rating of the risks in terms of the impact to the fund, which would also be low, moderate, medium, or high. And then the mitigating measures that have been implemented. And you may also sometimes add the cost thereon, if there's a cost factor in terms of the implementation of those mitigation measures. And lastly, the risk register will also contain details of the entity or person responsible for the management of the risk. So it may happen that the trustees will delegate that function. It could be, for instance, to the fund administrator. So that would have to be stated clearly in the risk register. And then it's also highly recommended that the monitoring process, which I mentioned earlier, should be ongoing, that it's conducted by subcommittee, so that the board of fund then has the comfort in knowing that there is a subcommittee that is actually has as one of its functions the monitoring, taking responsibility of the monitoring process within the risk management process globally. So it could reside with the audit and risk subcommittee or a governance subcommittee through the review of the risk register, or obviously getting feedback from whoever the fund has assigned to manage the risk. And if the fund administrator has an internal audit function, the board may also enlist its services to assist in the monitoring function. And then moving on to the last point in my presentation, broadening the risk identification process within pension funds. So we all know that we live in a very uncertain world now. We've just come out of a global pandemic, and then it looks like we went straight into a war. And effectively, this may have adverse effects on funds, or bring adverse effects on funds directly or indirectly. And also, the risk universe in the pension fund space has evolved over the years, and more in-depth involvement by the board is required in the fund's risk management process. So it shouldn't just be a tick box exercise wherein we say, oh, we have our risk register in place. It's actually about the quality of what is in the risk register. And the board needs to be involved in a more in-depth perspective, because we've seen in examples in the past where there have been governance failures, most of them emanate from the fact that there was little or inadequate risk management within those funds. There are some broader risks that the boards need to consider as well. Over and above, traditionally, I know most boards would look at internal risks, which pertain mainly to the operations of the fund, the compliance aspects of the fund. But there's other risks that boards can consider as well, such as the third-party risk, because most funds are reliant on third parties who provide services in terms of the day-to-day administration of the fund, maybe actuarial services, investment consulting, external audits, management of the fund's assets. So the operational failure of a third party obviously would pose a risk to the fund. There's cyber risks as well. We know we are now in the digital age. Most things are now done digitally, and we obviously then need to have the cyber risks in our radar. There's political risk as well. That would occur when there's changes to the country's laws and regulation, or as well as if there's any significant political changes or instability within the country. This may affect investment returns, as well as the going concern of participating employers. So I'll give an example. You can imagine if you were a trustee on a fund in Ukraine about 2 years ago, you would not have thought that in 2 years' time, the premises of your fund administrator would be razed to the ground, or that your fund would cease to exist because most of your members have had to flee and have become refugees. So that's just one example of where, instability within a country can actually lead to the fund becoming losing its going concern status. And then there's also a key person dependency risk. One example would be where a fund relies heavily on the principal officer. Might get to a point where the principal officer is now the holder of critical knowledge, institutional knowledge. And if that individual leaves the fund, they take with them some critical information that may not necessarily reside with the other participants, especially the board. And then you also have the dominant personality risk. This poses a threat to governance, to good governance, because should there be individuals that do not allow their viewpoints or suggestions to be challenged, it may, in the negative sense, they may then lead the board to actually make decisions that might be that might have a negative impact on the fund. So we also have to look at the external environment of the fund. So we shouldn't just look at the internal risk, but we should look at the external environment, because the fund exists where there is an external political environment, economic environment. So we do have, say, for instance, the issue of inflation. That would be something that would have under the economic risk, where we say in 2012, for example, the US dollar was sitting at 1:8 Rand. And currently now we're looking at it sitting at 1:18 Rand. So obviously in 10 years, our economy hasn't gone in the direction that we would have loved it to go. So those are the kind of risks that we need to consider as well. We've just come out of COVID-19. The board would have had to have the pandemic risk as a new risk coming onto their risk register, because there was an impact on funds. There were participating employers that couldn't pay in contributions for a specific period of time. There were participating employers that, there were employees or members of the fund that weren't working for a specific period of time. There was also retrenchments. So some funds would have seen, for instance, a shrinkage in terms of the number of members. So the above list is not exhaustive, and I would encourage that boards engage with risk management experts to assist with broadening their risk identification process, because the Act does say that where the trustees may not have specific expertise, then they can look to getting a third party to assist them with that. Thank you for your participation, and I look forward to answering your questions. Back to you, Nicole.
NBC Umbrella Retirement Fund. The NBC Umbrella Retirement Fund and the NBC Umbrella Pension Fund aim to accommodate the retirement funding needs of the small to medium-sized employer who want to provide professional yet cost-effective retirement solutions for employees. These funds are set up in terms of the Pension Funds Act to provide product options best suited to meet the needs of members who require the flexibility that is typically found in standalone funds. Employers are able to harness economies of scale through the NBC Umbrella Pension Fund or the NBC Umbrella Retirement Fund in terms of administration, governance, and investment costs. For more information, please see our website www.nbc.co.za or contact us on info@nbc.co.za.
Thank you so much for that presentation, Ndabe. Up next, I will be presenting on the Conduct of Financial Institutions Bill. So let's get into it. Firstly, let's go into what actually is the Conduct of Financial Institutions Bill. It's being called COFI. So it's a bill right now, which means it is not actually legislation. It is still up for commentary and amendments. So the COFI bill is going to outline what customers and industry stakeholders can expect from financial institutions. The aim is that it's going to strengthen the customer protection by putting in place a single comprehensive market conduct law in the financial sector, resulting in the consistent application of consumer protection principles just across the entire financial sector. The bill is intended to actually streamline the conduct requirements for financial institutions, which currently are being regulated by a number of financial sector laws. So what COFI is going to do is it's actually going to replace the conduct provisions in existing financial sector laws, which will entail the repeal of various provisions in certain acts or the repeal of others entirely. So this will ensure that all laws are mutually reinforcing and empower the Financial Sector Conduct Authority to appropriately use financial sector legislation to meet its market conduct mandate. So in this instance, I want to touch on COFI in terms of how it will affect the retirement fund space. So as it stands, what COFI is going to do is that boards of retirement funds will remain responsible and still accountable for ensuring compliance by a fund with all the applicable legislation, but now it'll just be as part of their broader duties. And given this important function, boards should be fit and proper, right? So in the case of member elected trustees, the focus is actually going to be on continual skills development through training, and they will not be licensed under COFI. However, for professional trustees and independent trustees, they will be required to be licensed, and they will be subject to fit and proper requirements as part of their wider regulatory obligations. So what I'm going to touch on is just a few changes that COFI is going to bring in terms of the retirement fund space. This is by no means, a tedious or detailed look at COFI, but rather just some highlights on what we can expect. So how will the Pension Funds Act actually be affected by COFI should it be become legislation? So the Pension Funds Act is going to be amended actually to be in line with the COFI bill and the overall framework in terms of the Financial Services Regulatory Authority. Okay, so the PFA will be renamed the Retirement Funds Act. Okay, so that's the first big change that will happen. And this is to better reflect the types of funds which are provided for and regulated by the statute, okay? So it's actually proposed that retirement funds will be required to be licensed under both the PFA, which will be at that stage the Retirement Fund Act, and also the COFI Act once it is law. And retirement funds will be subject to the requirements of in both laws to ensure consistency in the treatment of members of retirement funds. However, retirement fund benefit administrators and other service providers currently which are regulated under the Pension Funds Act will in future be licensed and authorized under the COFI Act only. So retirement funds will be they will need to ensure that they are following COFI and the Retirement Funds Act. However, administrators will actually be licensed under COFI only. So what will a fund actually need to do in order to make sure that it is in line with the requirements of COFI? Okay, so the first thing is it will need to ensure that its benefit structure is appropriate for the profile of its membership and that its benefits match the members' expectations. Okay, so, we're going to see with these points that it's actually in line with the concept of treating customers fairly. Okay, so the second thing is a fund will need to communicate with its member in clear and plain and unambiguous language, okay? Thirdly, a fund will need to ensure that there's no unreasonable barriers when members claim their benefit on retirement or withdraw from service, or when a member lodges a complaint, right? So these are the things that a fund will need to start to change already. And then a participating employer in a retirement fund will now be supervised by the FSCA, but only in relation to the employer's compliance with Section 13A of the Pension Funds Act, which we know is the section which regulates the contributions of members. Okay. Another point that I want to touch on is what's going to happen to state-owned pension funds in terms of COFI. So as it stands currently, the Government Employees Pension Fund and other state-owned pension funds are subject only to their dedicated laws. So they're not actually subject to the laws that we are facing in the retirement fund sphere. But however, COFI is looking at it this way. Given the large number of South Africans who contribute to these pension funds, including many of them being lower income earners, fund members should actually arguably be subject to the same member protection as those regulated through the Pension Funds Act. And actually consideration is being given to ensure that these funds are over time also regulated under the COFI Act. So that's going to be a big change because for this reason, the definition of pension fund is now going to include public sector funds. And fund members in these funds will also be able to lay complaints about poor treatment to a financial sector ombud, which currently, if you're part of a state-owned pension fund, you are not able to lay a complaint with an ombud, as no ombud actually has jurisdiction over state-owned funds. So the approach that COFI is actually having is that what's being proposed is that state-owned funds will be subject to further consultation and engagement before this bill is actually becomes legislation. So the next point I want to look at is what's going to be called the Central Unclaimed Benefits Fund. This, in terms of COFI, is going to be a new fund which will be established. It will be subject to regulations in terms of the Pension Funds Act, which at that point will be the Retirement Funds Act, and it will be governed by a board comprising of 6 people who will be appointed by the Financial Sector Conduct Authority after what we hope to be a transparent process of recruitment. So the COFI bill does not actually say that existing unclaimed benefit funds and other funds with liabilities for payment of unpaid benefits will have to transfer their liabilities of those benefits to this fund. So we're still waiting to see what's going to happen in terms of this newly when established central unclaimed benefit funds. Will current unclaimed benefit funds have to all transfer to this specific fund, or what will happen? So we're still going to wait for the discussion and comments on that one. The next point I'd like for us to look at is some definitions that are going to be changed or added by the COFI bill. Okay. So this is just a few. Obviously, we're not touching on everything, but just some that I thought we should look into are the definition of retirement fund will now be added, which will encompass all the funds regulated under the current Pension Funds Act. Each type of retirement fund will separately be defined, but the wording of these definitions will describe what the different funds actually do. Okay. The second definition that's going to be introduced is the definition of an umbrella fund. Okay. This will apply only to those umbrella funds known as a Type A umbrella fund. So i.e. those are umbrella funds which operate in terms of special rules and which apply to an individual participating employer. Okay. And then the last definition that I want to look at is the definition that will be introduced being what's called a sub-fund. Okay. A sub-fund is a section of the umbrella fund in which a particular employer participates, right? So the general rules of the sub-fund must be amended in order to provide for the asset, the liabilities, and the rights and obligations for each sub-fund, right? And this must be done separately and maintained separately. So there's going to be no cross subsidization between sub-funds will be permitted. And for an example, what I mean by this is where a surplus in one sub-fund cannot be used to fund another sub-fund, which is underfunded. So that's what's going to happen now. The next point I'd like to look at is how COFI is actually going to affect the FSCA. So what's going to happen is there's going to be a few amendments. Firstly, the FSCA will now have the right to cancel a fund's registration, which will be called its license, on proof that the fund has ceased to exist and not proof to its satisfaction as now required. So currently, the requirement is its satisfaction that a fund no longer exists, and thus the FSCA will be able to actually cancel a fund's license or registration. But when the COFI bill comes into play, what's going to happen is the FSCA will now only be allowed to cancel a fund's registration or license once there is proof that a fund has ceased to exist. Another point is that the FSCA will now be able to suspend a fund's license if it thinks that it will give the fund the opportunity to rectify its problems identified by the FSCA. So this just means that you'll be able to get suspended and you'll be given time to actually go through the issues that the FSCA might have identified in that specific fund. And this will allow the fund, instead of just being cancelled or having their license revoked, being able to just have a suspension period, rectify the issues, and then the license will be given back, will be brought back and become active. The next thing is that the FSCA will be able to reinstate with retrospective effect the registration, or what will be called the license of a fund, which was cancelled when the fund still had assets or liabilities, without the transparency and the accountability entailed in a court application for an order setting aside the cancellation of the fund's registration. Okay. Another point is that in terms of how the COFI bill is actually going to affect Section 37C of the Pension Funds Act, just to highlight 2 points that are going to happen there that I thought were interesting to mention is that, firstly, just a reminder that Section 37C has to do with death benefits. So the first thing that I thought was notable was that where a fund has successfully traced a dependent, the COFI bill will now, should it become a legislation, will require that where a dependent is traced successfully, the benefit must be paid to the dependent within 2 months of the fund tracing the dependent. That's the first point that I thought was quite interesting. The second thing is COFI will now have a specified age at which minor dependents and minor nominees must be paid the balance of their benefits where they are being paid in installments. So what this means is currently where it stands is that when a benefit is paid out to a beneficiary who might be a minor, there is the option that a board has in which they can pay a beneficiary in installments. Now, should this be the case, what the COFI bill is now going to subject the fund and the board to is that there has to be a time period on which the entire benefit is paid to a beneficiary. So currently there's no time period. So if you wanted to pay a specific beneficiary, within 5 interval installments until the age of 25, that can be done. But what COFI is going to introduce is that a minor beneficiary must be paid by the time they reach the age of majority, but the latest and last installment must be made by the time that they reach the age of 21. So there can be no further benefits still being withheld for a minor after they've reached the age of 21. Some other notable points just before I finish my presentation is that the FSCA is going to be able to actually reinstate is that some of the difficulties that are entailed with fund liquidations will be addressed by empowering the FSCA actually to remove a problematic liquidator from office and replace him or her. And this is to replace the liquidator, and also to replace a liquidator who has died before the liquidation of a fund has been completed. And this is obviously just to assist in order to ensure that the liquidations of a fund are actually done in a more streamlined and faster manner and efficient manner. So the FSCA is also going to be able to prescribe standards on any other matter that is appropriate and necessary for achieving the purposes of what will be at that point the Retirement Funds Act. And it will be able to determine the amount that should be set for administrative fees, penalties, and interest required to be paid in terms of the Pension Funds Act, and by whom and how they must be paid. So that was just the last point I wanted to add in terms of the powers that the FSCA will be given when the new COFI bill is actually enacted. And that will be the end of my presentation. And now we'll be taking questions. Everyone will be coming back on screen, and we're going to go through some of the questions that we've received through the chat. If you have a question, please do add it in the chat and we'll have a look at it.
Good morning, everybody. I'm so proud of my team who are able to present these complex topics for us today, and we do have a little bit of time for questions. So I suppose the only logical way is just to start at the top and go through the questions. Esther, the first one looks like one for you. What is the appropriate course of action if a phase rep stops being fit and proper?
All right, thank you for that question. So if a phase representative stops being fit and proper, the appropriate action is for the compliance officer to then debar that representative. But my advice is that because there's a requirement to maintain a competency register, the representative has a responsibility to also review this register to see how far they are from being competent. And if they see that there's a risk, they need to approach their manager so that they can perhaps be removed off the register if they cannot comply within the time frame that they're required to do so.
Yeah, Esther, I suppose that depends on the reason for not being fit and proper, nay?
That's also one thing, because I think I'm looking at it more from a perspective of if, for instance, a person doesn't manage to do their regulatory exams on time or class of business on time. But where we're looking at more serious thing, say, for instance, we're dealing with honesty and integrity, and it's a matter of you being found guilty, or you go through a whole inquiry within the business. Now, that's a different case altogether. Then the financial service provider has a responsibility to start the debarment process, because the FSCA do not do that for you. And then they start the debarment process, and if that person is not satisfied with that, they would then need to appeal with the FSTC.
I agree with you, Esther. I think the second question is also for you. What is the risk if I think this refers to a consumer, nay? What is the risk if I purchase a financial product from an unregistered phase representative?
Okay, the risk with that is that if you purchase a financial product from an unregistered phase representative, it's likely maybe that the covers that you're offered in law may not apply to you. So what you need to do the minute you realize that that is the case is you need to report it to the FSCA so that there's an investigation into that representative. Because sometimes what happens is you try to report it to the financial service provider that the person represents, which is the adequate way of doing it. But it might delay in getting you the relief that you require. So it needs to be reported directly to the FSCA as soon as possible so that you can get some sort of relief as soon as possible in that case.
Esther, the next one is also for you, and I think you have answered it in your presentation, but maybe you can just glance over it again. And the question is, what are the obligations of a compliance officer when it comes to ensuring that the FSP reps are fit and proper?
All right, so the compliance officer is required to maintain what we call now a competency register. We used to call it a representative register, but with the fit and proper requirements of 2017, you're required to maintain what we call a competence register, and this register depends on the type of company that you're dealing with. A spreadsheet would be sufficient for a small company, but where you're dealing with a bigger company and perhaps the competency register is much larger, then you would be required to ensure that there's sort of some sort of automated way of dealing with it and reporting back that happens to the key persons of the business and key individuals, and that the representatives themselves have access to it so that they have a better understanding of what they need to do. So the compliance officer manages that whole process and provides feedback to the relevant representatives and key persons or any areas that they need to be alerted of.
Yeah, I'm going to say the following tongue in cheek is that, so it's not your job to ensure that they are fit and proper, nay.
Exactly.
You just record and report, nay.
I like that you caught that. That's exactly what so I'm just there to make sure everyone does what they need to do. Thank you for that.
Esther, you have many questions. If a phase rep has adverse listings or judgments on his or her credit report, will such representative be considered fit and proper?
All right, so when we're looking at adverse listings or judgments, again, we need to look at what type of judgments those are. When I was going through my presentation, I mentioned that where it relates specifically to fraud or anything that might discredit you from an honesty and integrity perspective, then you would not be considered to be fit and proper, and there you can't be added as a representative. Also, we need to look at when those judgments or findings were obtained, if there's been any remedial action that's been taken since, if it's a judgment, if it's been over 5 years. So each case, what I'm trying to say is each case needs to be looked at on its own merits. There's no one cast in stone answer for each and every specific individual.
And you did deal with this in your presentation, so I'm not going to put it to you, but maybe just remind everyone, what are the CPD requirements for key individuals versus that of a representative?
All right, so for both key individuals and representatives that are no longer under supervision, the CPD requirements are the same. So those are based on the specific categories that you're licensed for. If we're looking at, for instance, NBC Holdings, that is a Category 1 license, but that collects premiums, our CPD requirements would be 18 CPD points for both key individuals and representatives. But as I mentioned, even though this is not a requirement in law, those representatives that are not under supervision would be required to do CPD for specific training that is considered compulsory within a business. So even though they don't have a regulatory requirement to obtain CPD points, there are certain trainings that become compulsory within that company that they have to, and most of that training would be CPD accredited. So yeah, I don't know if that answers you.
Yeah, I think we must repeat here, something that we continuously say in compliance, and that is not a checkbox exercise.
Exactly.
So 18 hours, or 18 points, it doesn't necessarily equate to an hour. You shouldn't stop there. I think that's the point that you're trying to make, Nay.
That's correct, yeah.
Okay, Esther, it looks like I'm done with you. Carla, it's your turn now. If an employer granted a study loan to an employee, may the balance of such loan be deducted from member's benefit when he leaves employment? I think you're on mute, Carla.
My apologies, Lee. Thank you for the question. So the short answer is no. I'm going to take you back to the specific requirements in terms of the Act, Section 37D, which requires the damages to be caused by theft, fraud, dishonesty, and misconduct. And then I explained misconduct there has to be an element of intent. So a study loan does not fall within the ambit of that specific section of the Act. And we actually do get a lot of those as well.
We do. So in that regard, the employer will be in the same position as any ordinary creditor of that member. We will not allow the bank to come and attach retirement savings for an overdraft. And similarly, you cannot deduct the study loan. You addressed this in your presentation, but I am going to ask you the question anyways. Will criminal proceedings against a member suffice for withholding? And I think, maybe this audience member just needs us to deal with the OPFA, the Pension Funds Adjudicator's opinion at the RFA seminar, and we're allowed to respectfully disagree with them. Nay, please share with us your views on that point.
All right, Lip. So I tend to agree in a sense that there's no control over how quick you can drive the criminal proceedings. It's not in your prerogative if this matter is going to proceed or not. The matters of the fact is going to be evaluated by the investigating officer, and they might either proceed with the docket or not. Should they decide to proceed, it might be indefinite. I don't know how long it's going to take. So I tend to agree with what was stated by the PFA at the RFA conference.
Yeah, and I think it's got to do with our reality there, that SAPs take an inordinate amount of time to finalize investigations, etc., etc. The next question, this looks complex, Carla. An employer's civil action against an employee will be based on dialect. Only unlawfulness is required to be proven. Why the emphasis on dishonesty? That is a tough question.
That is a tough question, Lip. I don't know what the legislator thought or considered when they specifically wrote that into Section 37D. I think because of a lot of Lip, you're welcome to come in here as well. For the specific reasons as to why, and I agree with the question. The first three elements is for dialect and civil procedure.
Yeah, that does appear to be an anomaly. But I think our advice to our clients has to be restricted to what the law says. And what the law says at the moment is that the misconduct must include an element of dishonesty. What happens after that, and remember, the pension fund only considers this for purposes of withholding, not for purposes of deciding who will win the case at the end of the day. So even though you may wonder about these things philosophically, our advice has to comply with what the court judgments say. And what the court judgments say is that there has to be an element of dishonesty before the board considers to withhold a benefit. Is the burden on trustees perhaps too high, Carla? They are not a court of law, but required to decide whether to withhold or not. That is also interesting.
Yeah, it is quite a high burden. I agree with the question. But like I said, there's all these factors that they have to consider to give the employer the opportunity to regain the losses that was suffered. So like I mentioned in my presentation, it's not for the board to decide on a balance of probabilities on the matter. Is the member guilty or not? It's basically to consider the fact that what are the prospects of success if they have read through the disciplinary hearings, they've read through the supporting court papers. That would give a clear indication as to, is this just a bogus claim against this member, or do they actually have a prospect of success? And as well as, like I said in the JEFTA case, they would also get an indication as to if the member was given an opportunity to respond to the allegations. We do see in practice a lot of the times they default, or they don't come to the party, they don't give their version, they just remain silent. So that also gives us would give the board a direction as to the would it be rightful to withhold?
Yeah, I just want to conclude on that point. So if the trustee's decision to withhold or not is ever placed under scrutiny, either in a court or at the adjudicator's office, the only test will be, and this is because the trustees are exercising discretion, the only test will be, did you exercise your discretion lawfully? And that entails asking two questions, and that is, did you consider all relevant factors? And secondly, did you disregard all irrelevant factors? And that's the test. So it's unlikely that a court will replace the trustee's decision with its own if it can be shown that the trustees exercised that discretion lawfully.
100%.
Can the employer also recover the legal costs from the poor member?
Sorry, Liv, please repeat. You just broke up for a while.
Can the employer also recover the legal costs from a member to be deducted from their benefit?
Yes.
Now that's actually a lucky easy one, eh?
Yeah, thanks for the easy question. So the Act does make provision for reasonable legal costs. So I won't advise the employer to brief the most expensive senior counsel on a very straightforward matter. So reasonability comes into play.
Okay. If the fund has afforded the member the opportunity to state his case, but he does not oblige, you spoke about that just a while ago, what then? Does it mean that the fund has complied?
So the fund can always, when this goes to the adjudicator or court, say, we've given this member 2-3 opportunities to respond to the allegations made against him. The file can't be pended indefinitely. I mean, because you have to balance fair treatment to the employer and the member. So the employer would be prejudiced if we just delay the process of decision making on whether to withhold or not.
That doesn't mean that the board won't exercise their discretion, eh?
They still have to exercise the discretion.
Absolutely.
Absolutely.
In the absence of any allegations by the member or a response from the member, the board must still exercise its discretion.
Yeah, so the case law merely states that an opportunity has to be given to the member to respond. It's not within the fund's control whether the member will in fact respond or not.
I agree with you. Okay, I think we dealt with this one before, but let's just touch on it again. What about deductions falling outside of damages? Acknowledgement of liability signed for monies lent by the employee, authorizing the fund to repay any outstanding amount upon termination. Just to recap, Carla, you can recap for us.
Yes, so like we said, student loans, excess payments to your short-term insurer, all of that does not fall within the ambit of Section 37D. Specifically, like I mentioned, if you want me to repeat, theft, fraud, misconduct.
No, don't do that. I do want to mention a practical difficulty that we sometimes are faced with. So the member leaves employment, and the employer and employee part ways on amicable grounds. Then for some reason, this member, while he's waiting for his pension benefit to be paid to him, he runs into a crisis, and it can be many things. His child can fall from a tree. I know it sounds horrible, but these are things that happen. Then approaches his former employer for an interim loan on the premise that as soon as the Provident Fund benefit is paid to that member, the portion that was lent to him by the employer will be paid to the employer directly. That would be unlawful. But those are some of the practical examples that do exist. Also, the most problematic one is probably advance payments in the case of the death of a member, where the funds are sometimes tempted to pay in advance to somebody to take care of the funeral, and then the employer would typically want to be refunded. That would not be a lawful refund.
So I think it would be prudent for the fund or the administrator, when we engage with participating employers on these issues, that they be aware that this will not fall within Section 37G, because they just assume. And in practice, you end up dealing with a very irate frustrated employer, and you have to explain you do still have recourse, just not against the fund.
I agree with you fully. It looks like we're done with you, Carla. Your turn, and Daba. How does a pension fund record a risk that is very remote or unlikely to materialize?
Okay, thank you for that question. Any risk, if we state that it's remote, it means there is a slight chance or likelihood that it may impact the fund. But at the risk assessment phase of the risk management process, we look at two things: the likelihood of the risk occurring, and secondly, the impact of that risk to the fund. So the likelihood of the risk occurring may be low in terms of our assessment, but it might have a very high impact. So we would record that risk in our risk register, and eventually the risk rating for that risk might be low. So meaning we're saying that in terms of the risk rating, we rate it as low. But for somebody that comes through to look at your risk register, it says to them that you did consider that risk. So that is why it's important to record any, as I said, the trustees must ask themselves the questions: what could go wrong? So for as long as that particular risk comes in as an answer to that question, it's always best to have it recorded in your risk register, even if it's going to have a low risk rating. Thanks.
Okay, that makes perfect sense, Nay.
Yeah.
Is the potential grey listing of South Africa by the FATC a risk for pension funds?
Well, I think we would have to look at it to say, is there going to be a direct impact or indirect impact? So for me, the biggest risk there would be, how do other countries where the funds may potentially want to invest react to the grey listing? So for example, we do know that if a country goes into junk status, or it gets a junk status rating, there's some countries in Europe that actually then state that none of the entities registered in that particular country can invest in a country that has that junk status. So it would have an impact, and there are risks from an investment's perspective, and the fund would have to engage with the investment consultant, and as well as with the asset managers if they're in direct contact, just to say to them, look, with this potential grey listing that is coming, or that may happen, what could be the impact to us as a fund or our investments? So yes, definitely there is an element of risk there for pension funds.
Thank you, Ndaba. The next question is: will all risks that pension funds face, like a credit downgrading or even the war in Ukraine, affect all pension funds in the same way?
Well, the answer is, it's a yes and no answer. So yes, funds will be affected in the same way, because there is sort of general adverse effects of that. So the global economy obviously has suffered, sort of negatively as a result of the war in Ukraine. So that obviously then also speaks into, investments, fund investments. There would be a negative impact there on returns as well. So that would be one example of where it affects the funds in the same way. But it may also happen that certain industries are affected, say, for instance, by the war in Ukraine. If, for instance, there was to be a shortage of oil, or of a component that where Russia is one of the largest exporters, and we have companies in South Africa that rely on that particular commodity, it will impact, obviously, those participating employers, and might threaten their very existence, which then has an impact on the fund in terms of it being a going concern as well. So, as I said, it's yes and no. There will be the general adverse effects, and there may be some which may be specific to certain industries.
I think the point you're trying to make, Ndaba, is that you can't copy and paste, nay?
No, you can't. You can't. Yeah. So it's important as well, as I said, that the board needs to the trustees need to apply their minds, looking at the fund, specific risks, but also looking externally in terms of, what's going on in the world, what's going on in the external environment. And depending on maybe the industry that the participating employers are in, it's also looking at that to say, how are they impacted by the events, in the external environment, and how does that then push onto the fund in terms of, any adverse effects.
The next question is something I've never encountered in practice, but I'm going to ask it anyways. Does the regulator have a right to look at a fund's risk register?
Yes, they would, because as I said earlier, risk management is part of the fiduciary duties of the trustees. So when the regulator does site visits, they obviously want to see that the risk management process is being done properly. And as I said, the risk register is a risk management tool. So that would be one of the documents that they would request, as well as any minutes of any subcommittee that may be delegated to actually run with the risk management process. So yes, definitely the regulator has a right to access the risk register of the fund.
And there I learned something today. And Daba, should funds include ESG considerations in the risk management framework?
I think it's more on from a good governance perspective. I would include it as a risk in terms of where our investments potentially don't comply, or where we are invested, there's a non-compliance from an ESG perspective. So I would put it more on the compliance side in terms of the risks out.
I agree with you.
Under the compliance side, and yes, it's something to consider. It's something that definitely should be included in the risk register as well.
I think this is an example of how the issues in our industry dovetail there. So let's say a fund decides to invest in infrastructure, investment.
Yes.
Then ESG itself is not on the risk register, but that infrastructure investment risk will be on the risk register there.
Yes.
So
yes.
Indirectly, you will be dealing with it in your risk management.
And if I may just make one point, Leap, I think there is a positive side to risk management. So you can also do a risk assessment where, for instance, we know now there's we have challenges with consistent power, having consistent electricity. There's a move towards IPPs. So a fund may decide to invest directly in that space, and then they would do a risk assessment to obviously then say, so the risk management process also has a positive side to it, because when there's potential opportunities, we still have to follow that risk management process, the 4-step process as well.
I agree with you fully. For me, the most important aspect is that it forces you to be proactive.
Yes.
Where you stop reacting to calamities and you actually look forward and you start preventing any potential risks.
Yes.
Thanks, Ndaba. I see we're going over to Kofi now. Nicole, are you on the screen?
Hi, Leap. We've lost Nicole. She's not available at the moment. So if you can also do the close when you're done, please.
Okay. So the question is, Kofi sounds complex. Funds and service providers will see many added layers of compliance. Who will carry these costs? Unfortunately, that is a reality. We will have to make significant changes to everything that we do, from service level agreements to investment policy statements, etc. And we will have to carry that costs. And that is why it's so important that we as an industry remain engaged with National Treasury with comments and input into the finalization of COFI. The second question, when do we expect COFI to be officially promulgated? Yeah, that's a tough one. So the regulator promised us, round about this time of 2022, we would have seen the next draft, and that is definitely on the cards, a third draft of COFI. So we're expecting it any time now. But as to a reasonable expectation, I cannot guess when COFI will become effective. The next question is, will the FSCA have the authority to hold employers accountable for contributions under the proposed COFI provisions? I think this question relates to the remark that Nicole made in her presentation, that participating employers in retirement funds will be a regulated entity in terms of the new COFI. So I would imagine that they would have that power. I think it will make a massive difference with regards to non-compliance. If we find ways of holding non-compliant employers a bit, to hold them accountable, not a bit accountable, to hold them accountable, because currently the only avenues that funds can explore is a criminal case, which, goes back to Carla's remark about, SAPS being overwhelmed and not being able to finalize the investigations. Or the fund must incur legal expenses, to hold those employers accountable, and that is far from ideal. This is an interesting question. We saw the Office of the Pension Funds adjudicate the name change recently. Is this because of COFI? Will the pension funds adjudicator continue in the new COFI dispensation? Carla, you used to work at that office. Do you have any idea?
No, I don't.
So what it's got to do with is COFI proposes that all legal tribunals, and I say legal tribunals in inverted commas because they are quasi-judicial forums, will now be housed under one roof. So there will be one financial ombud in terms of COFI, and it will incorporate the short-term ombudsman, the long-term ombudsman, the phase ombudsman, even the credit regulator, and then the pension funds adjudicator. But our expectation as the industry has always been that this is quite some time into the future still, that we aren't ready to accommodate such changes just now. But we will watch this keenly and communicate to our clients as soon as we learn more. Here's an interesting question. Why was the discussion paper on unclaimed benefits released by the FSCA recently? Why is it no longer part of COFI? I think the interesting aspect there is that maybe the regulator wanted to bring changes to the unclaimed benefit regime quicker than the legislative process with COFI is currently happening. And the National Treasury has indicated that unclaimed benefits will no longer form part of the COFI discussion. Doesn't change anything. The proposals are more or less the same as it had been under COFI. But if the regulator achieves what they are aiming for by this discussion paper, you should expect some legislation on unclaimed benefits sooner than the actual COFI Act. Another question, and this is the last question, and it's perfect because it's 11:59. So, is there any reference to the two-pot system in COFI? No. So, the two-pot system is governed in terms of revenue laws, and as you know, COFI and the Pension Funds Act are totally separate from taxation and revenue acts. And with that, that is the end of our spiel. Thank you for attending. So we are in the process here at NBC to look at the format of the legal seminars. We would like to see a significant improvement in the attendance, and we want to investigate different types of engagement with our clients. So watch out for communication through your fund consultants shortly about how we will be conducting the legal seminars next year. Expect something very similar to this, with a few changes where we may see some value in physical engagement. We are still investigating that. Just logistically, please remember to give us your feedback about what you witnessed today, whether you learned anything, if you have any proposals of how we can improve on the way in which we present these seminars. And then please remember to download your CPD certificate before you log off. And with that, I can't believe I'm saying this on the 4th of November. If we don't see each other again, have a Merry Christmas, travel safely, and we'll see you in the next year. Thank you, everyone.